In these cases, we're talking about kids making decisions that could result in lifelong lack of fertility, lifelong lack of sexual function, a lifetime of dealing with cognitive impairments, tumors, bone density disorders, blood clots. So there are really serious risks, and every systematic analysis of the evidence shows minimal to no benefits to kids from these procedures.
Awful. That was Tennessee's Republican Attorney General on the Supreme Court oral arguments in the case over transgender treatment. It involves the constitutionality of state laws that ban gender transition medical procedures for minors, for people under the age of 18, is what's being discussed here. The justices appeared divided on this issue after listening for over 2 hours to the arguments that were presented, challenging Tennessee's ban against these procedures for minors. Watch this.
You say there are benefits from allowing these treatments, but there are also harms, right, from allowing these treatments. At least the state says so, including lost fertility, the physical and psychological effects on those who later change their mind and want to detransition, which I don't think we can ignore.
After the filing of your petition, of course, we saw the release of the Cass report in the United Kingdom, which found a complete lack of high-quality evidence showing that the benefits of the treatments in question here outweigh the risks.
My understanding is that the Constitution leaves that question to the people's representatives rather than to 9 people, none of whom is a doctor.
So the Supreme Court Justice Ketanji Brown Jackson made this comparison, which is getting a lot of attention. Listen carefully to what she's getting at here.
They sound in the same kinds of arguments that were made back in the day, 50s, 60s, with respect to racial classifications and inconsistencies. I'm thinking in particular about Loving. The court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. It's sort of the same thing.
Okay, so she's making the suggestion that interracial marriage and allowing it or banning it back decades ago has some equivalency or some comparison as a precedent to allowing children under the age of 18 to medically attempt to change their gender. Critics sounded off on social media, one saying, quote, "We don't let minors get married for a reason, too." Another, "The false equivalence train has left the station." And this one, "How can someone who doesn't know what a woman is rule on a case involving gender?" That last comment, obviously a reference to Jackson's confirmation hearing in 2022 and this memorable moment.
Can you provide a definition for the word woman?
Can I provide a definition?
Mm-hmm.
No.
Yeah.
I can't.
You can't?
Not in this context.
So
I'm not a biologist.
The meaning of the word woman is so unclear and controversial that you can't give me a definition?
Okay, Jonathan Turley, Fox News contributor and George Washington University law professor, joins us. Jonathan, good to have you. Let's focus on Ketanji Brown Jackson first here, and I want to get your take on the comparison that she made and what it tells us about her legal thinking and her approach to this issue.
Well, it was baffling for many of us that heard that come up in oral argument, but it was consistent with an effort, but particularly among the liberal justices, to portray any questioning of the science here and the basis for the Tennessee law as effective discrimination based upon gender identity or upon sexual orientation or gender generally. And that was a bit of an overreach for most of us. And when we heard that, I mean, this really does not raise the Loving case. I mean, the issue here for the state and 23 other states is that they believe that the medical record here, the science, is in conflict. And you have reports by recognized and respected bodies saying that we think that there are significant risks here. And then you have the Cass report saying we didn't really find any measurable benefits to balance against those risks. You know, those are all medical opinions that have to be weighed here. But the justices on the left tended to be fairly dismissive of that and suggested that the court should just step in and say, you know what, you cannot prevent this from happening if you are a given state. If you are half this country, half the states, we are going to say that you cannot take this preventative or protective measure.
Okay, another topic that I want to get to with you, Jonathan. The president-elect, Donald Trump, is pushing a Georgia appeals court to throw out the Fulton County District Attorney Fani Willis's case against him. It accuses him of trying to overturn the 2020 presidential election results in the state of Georgia. Now, the president-elect's lawyers argue that this case should be dismissed before Trump's inauguration on January the 20th, citing presidential immunity. His classified documents and federal interference cases have already been tossed. Trump's attorney filed a motion to dismiss his New York criminal case on Monday as well. Your thoughts on this latest move to try to excise this Georgia case from the docket?
Well, you know, this entire case is leaking like a sieve, and it always has, because it was based on, in my view, a ridiculous RICO theory to get to the president. There are some crimes in this case. I think they're relatively minor against some defendants, like unauthorized access. But to get the president, they had to create this real Rube Goldberg type of racketeering theory that I don't think will hold up upon review. And on top of that, you have Willis's own conduct and whether she should be removed from the case. So it's a big debate as to what will bring this case down, but there are a lot of possibilities here. Now, the fact is that courts tend to try to leave these to juries, leave these to fact finders, and so Willis knows she has an advantage. But just keep in mind that this entire case is teetering, in my view, legally. And I just can't see, even if she was able to secure a conviction, that she would be able to sustain it on appeal. But I don't believe this case should go to jury. I don't think it should go to trial. I think it's a laughable case against the former president.
Just quickly, Jonathan, what's your take on Judge McAfee? And do you think, based on what we've learned about him through this process, that he's inclined to toss it?
Well, you know, he just delivered a fairly large blow to Willis because he said that she had to turn over any documents relating to communications with the J6 committee and the special counsel. He has shown, I think, a fair degree of balance here. I've had a lot of respect for some of the decisions he's reached. So I have no objection to him as a judge. My objection is the underlying case.
Okay, let's talk a little bit about what's going on right now in downtown Manhattan, where the jury is deliberating day 3 now in the case that has really caught the attention of the nation, Daniel Penny's trial. This jury is in the process of deciding if this Marine veteran is guilty of killing Jordan Neely in a struggle on a New York City subway last year. Yesterday, the jurors did ask for a few issues to review in testimony and in video evidence. The New York Post editorial board calling out District Attorney Alvin Bragg, calling him a menace to our society. And here's the quote from this editorial. Bragg, playing to race-obsessed activists, brought charges of second-degree manslaughter plus as insurance in hopes that the jury would agree to the lesser charge of negligent homicide. So he's given them 2 options here. They go on to say, even if Penny is found innocent on all charges, his ordeal still sends a grim message to all New Yorkers. Don't think about standing up to protect the innocent. So that is the editorial board's take on that at the New York Post. What's yours, Jonathan?
I think the editors are correct in every respect of that editorial. I can't imagine someone on the subway today who's familiar with this case taking the risk that they would be put through this same ordeal by stepping up and trying to protect fellow riders. This case, in my view, is absurd. I don't see the basis for it. I was hoping for a quick acquittal. I am encouraged that some of the evidence they're asking for, I think, works to Penny's favor, including the cross-examination of the pathologist. I thought that cross-examination was very effective. But you can easily have a couple of holdout jurors here who want to see a conviction, particularly on that lesser standard. So, you can have this go for days as they work on one or two jurors. And ultimately, if they say they're a jury that is deadlocked, the judge will normally give them an order to say, try again. And sometimes that's enough to get people off their mark. But we're obviously all waiting. But I was hoping for a quick acquittal to send a different message than the one you just referred to.
Yeah. All right, we wait for this jury, for them to make their decision. It has to be unanimous, as you pointed out, Jonathan, and we'll see if they ask for more information today. As you pointed out, they wanted the cross-examination of the medical examiner, which was interesting, because that medical examiner had said that it was death by chokehold, and they wanted the cross on that discussion. Jonathan, thanks. We'll see you later. Good to see you.
Hey everyone, I'm Emily Campagno. Catch me and my co-hosts Harris Faulkner and Kaylee McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.